Good morning. As Judge Cohen indicated, I'm Judge Lambert. I'll be presiding today. Welcome to another Zoom session of oral argument of the 5th DCA, our new world here. We have Judge Cohen from Orange County is on the panel, and we see Judge Harris. He's from Brevard County. He is on the panel. Again, I'm Judge Lambert. Our first case is 18-3265, McKinney and McQueen versus Graham. We are on YouTube, so the millions of people will be streaming in watching us today. So just keep that in mind when you argue. And also, each side has 20 minutes. You'll see there's a clock over there. We'll leave 5 minutes for rebuttal for the default time for the appellant, unless Mr. Webster, you would like something different than 5 minutes, and we'll have the clock reset accordingly. But other than that, if we're ready to go, Mr. Webster, go ahead when you're ready.
Thank you, Judge. My name is Peter Webster, and I represent the appellants. I'm going to try and save at least 4 minutes, but we'll see how that works.
Okay.
A clear legal error occurred in this case when the trial court held that the issue of entitlement to punitive damages must be submitted to the jury even though entitlement had been admitted. This error was compounded by the court's rulings permitting evidence of intoxication and refusing to allow evidence of bias on the part of two of plaintiffs' principal treating physician witnesses. These errors...
We're familiar with the facts and the issues involved. I'd like to start with asking you, how would you distinguish the Coucher opinion?
I think it's fairly easy, Your Honor. Coucher just really doesn't have anything to say about this case. Coucher was a case. It involved there were two issues. One was whether it was reversible error not to try compensatory damages before one jury and then punitive damage issues before a separate jury. And the other issue was whether it was error to deny a motion for mistrial made after the uninsured tortfeasor had settled the punitive damage claim during trial. In a 2-to-1 decision with Judge Cobb dissenting, the majority held that neither ruling had been an abuse of discretion. Of course, the opinion did not hold that the issue of entitlement to punitive damages should be presented to a jury even when that's been admitted by the defendant. And it did not address or hold that it was proper to submit evidence of intoxication in a case of this sort, because in Coucher, no evidence of intoxication was offered, and therefore it simply couldn't have been an issue.
Well, with all due respect, Mr. Webster, it seems to me that in Coucher it was worse than that, because in Coucher, the trial court specifically told the jury during the compensatory damages portion of the trial that the defendant in the case had been driving under the influence of alcohol. And it seems to me that that's a worse position for a defendant to be in than allowing the plaintiff to put in evidence of intoxication. There you've got the imprinter of the court telling the jury that the defendant had been driving while intoxicated. So your distinction that the jury hadn't heard evidence of intoxication doesn't seem persuasive to me.
Well, Your Honor, it certainly was a fact that the jury didn't hear any evidence of intoxication, but to the extent you believe Coucher was a tough case because the judge had actually instructed the jury about intoxication. In this case, the judge did that at the beginning of the trial and at the end of the trial, and that's our first issue regarding error. The judge.
Well, no, but we've got authority, and so I'm trying to understand how we distinguish that authority because that was not deemed reversible error in Coucher. And I understand that there are some cases, and we're going to talk, I'm sure, with Mr. Carlisle, the Swanson case, out of the 2nd District, and the Dixon case out of the 3rd District, that go a different direction on this. I'm just trying to understand why you don't think that Coucher has us going in a different direction than the 2nd and the 3rd.
Okay, I'll try again. We have 3 issues in this case. The first is that it was an error of law for the trial judge to allow evidence of intoxication, or to instruct the jury on intoxication, to instruct the jury regarding punitive damages, to submit that issue to them, despite the fact that defendant McKinney had admitted liability for punitive damages. That's issue one.
It seems that's exactly what happened in Coucher.
No, it's not, Your Honor. Respectfully, it's not. It wasn't raised as an issue of error in Coucher. The 2 issues that were raised in Coucher were, first, whether it was error, whether it was an abuse of discretion not to hold 2 separate trials before 2 separate juries. The second issue, whether it was an abuse of discretion not to declare a mistrial when the tortfeasor defendant settled the punitive damage claim during trial. Those were the only 2 issues Coucher decided. They did not decide any issue regarding admissibility of evidence of intoxication, and they did not decide any issue regarding whether entitlement must be decided by a jury, even when that issue has been admitted. And I think for those reasons, the case is clearly distinguishable. Probably the reason why neither Swanson nor Dixon mentions Coucher.
Yeah.
And the fact of the matter is, if you read Judge Cobb's excellent dissent, and frankly, I think Judge Cobb had it right in that case, but because we don't raise the separate trial issue on appeal, that issue is just not involved here. And so Coucher is distinguishable.
Okay. All right. Mr. Webster, let me ask this. Let's assume that we agree with your proposition that it's error to inform the jury as to the defendant's intoxication when both compensatory damages are admitted, at least the right to the compensatory and the punitives. What happens during voir dire? Because you're going to have the same jury for the punitive damage claim that you had for the compensatory damage claim. And it seems that once you start talking to the jury about this on voir dire, that the cat's out of the bag, so to speak.
Well, certainly that's a problem, Your Honor. And I would suggest to you that potential problem is good reason why the dissent in the Coucher case was correct, that you ought to try these cases before 2 separate juries, because obviously the punitive damage claim and the evidence regarding punitive damages is only admissible as to the active tortfeasor. And it can't
well, but 2 juries is not the procedure that the Florida Supreme Court has set forth.
Well, the procedure they set forth, respectfully, Your Honor, in W.R. Grace applies, we submit, only in situations where the defendant is contesting both compensatory and punitive liability, and where the defendant is the actual active tortfeasor. Grace was not a case where you had one party who was only vicariously liable for the tort of the active tortfeasor. Grace was an asbestos case. And Grace was, the bifurcated procedure in Grace was actually designed to protect defendants by not requiring them to submit evidence of prior punitive damage awards before a decision as to punitive damages had been made in their case.
But I don't believe that, in your brief or below that there was a request for two separate juries.
There wasn't, Your Honor.
And we have an opinion out of our court saying that you're not entitled to
Well,
two separate juries.
and you asked me how you deal with the voir dire problem.
Right.
I think that's the right way to deal with it. But another way to deal with it is to severely limit the amount of questioning that can be done during voir dire. That was pretty much done here. It didn't become a big issue in voir dire here. And of course, we objected immediately before voir dire to any questioning about that, renewed our motion for separate trials. But the key, I think, is if the jury doesn't hear any instructions from the judge, contrary to the case here where the judge instructed the jury twice that Mr. McKinney had been driving an automobile while impaired, that his blood alcohol readings had been 0.270 and 0.281, that he admitted liability for punitive damages, and you had evidence of all of that. That's what hurts in a case like this, because if the jury's asked questions about punitive damages, but there's no evidence and there's no instructions, they may have something in the back of their mind, but the court's going to tell them at the end of the case, you're to decide this case based on the evidence you've heard and the instructions I'm going to give you, and only based on the evidence you've heard and the instructions I'm going to give you.
Mr. Webster, do you know how many times during the course of the trial counsel for the plaintiff mentioned this issue?
In terms of presentation of evidence, or in terms of
either presentation of evidence or discussion?
Well,
Argument.
The counsel for the plaintiff mentioned it. First of all, we have to understand that the judge at the beginning of the trial instructed the jury.
Your answer is you don't know. That's okay.
No, I do know, Your Honor. I'm sorry, I do. But you have to set it up by explaining that first the judge set all of this out for the jury. And then in his opening statement, the plaintiff's trial lawyer followed right up by saying, first, the facts you heard the judge just tell you, he had a breath alcohol limit of 0.270 and 0.282, and the legal limit is 0.08. The evidence in this case will show that he had 3.5 times the legal limit of alcohol. And then during his case, he published to the jury a whole bunch of admissions. We submit none of which should have been published, because all they did was establish this wasn't an issue. But he published to the jury, Mr. McKinney admitted that he was driving under the influence. He admitted that the tests that were done showed 0.270, 0.281. And then
all right, Mr. Webster, I was actually looking for a number. I don't want to get too caught up in the weeds here, because
okay,
I do.
Well,
I do
all of that.
Excuse me. I do want to talk a little bit about the issue of cross-examination of the expert witnesses.
Yes, sir. The bias issue.
Right.
Okay. There were two expert treating physicians who testified. Dr. Mahan, the radiologist, and Dr. Masson, who was the surgeon. We sought to offer evidence demonstrating that they were both close personal friends of plaintiff's trial lawyer. The trial judge, with regard to Dr. Mahan, the trial judge allowed us to ask whether he and the attorney were personal friends, and if so, for how long. However, the trial judge accepted plaintiff's attorney's argument that delving any further into the specifics of that friendship would be invasive and privileged. And therefore, he refused to allow us to establish that Dr. Mahan had been a groomsman in the attorney's wedding, that he'd been to the attorney's home many times, and that they had had meals together. And of course, on appeal, the plaintiff has abandoned the invasive and privileged argument and instead argues that that evidence would have only been cumulative, collateral, and of minimal relevance at best. The proffer took 4 pages of the transcript. It's readily apparent that the trial court's rulings were irreconcilable with the law in Florida that provides for liberal cross-examination to establish bias. And moreover, it's fairly clear that the questions were relevant and weren't cumulative or collateral. Now, with regard to Dr. Masson, we have a little bit different situation. Dr. Masson testified by video deposition, and we asked to play to the jury or to have read to the jury Dr. Masson's refusal to answer questions regarding his relationship with the plaintiff's trial attorney. And the trial judge denied that mostly, and this is a quote, mostly because all the designations and responses are untimely. We explained to the trial judge that we couldn't make counter designations until the plaintiff had made his designations. He did that late on the Friday before trial, and within a few hours, we submitted our counter designations. So we wanted to play or read Dr. Masson's refusal to answer questions regarding his friendship. We also wanted to put in Facebook evidence demonstrating that in fact, Dr. Masson and plaintiff's attorney were friends. On appeal, plaintiff's only argument is that we have failed to establish that the evidence we wanted to put in was competent as to the existence of a friendship. I believe if you look at the Facebook evidence we sought to put in, which starts at page 2328 of the supplemental record, you'll see that it was pretty clearly competent on the issue of friendship. And of course, weight is a question for the jury. I see I'm well into my rebuttal time, so I'll save what I have left.
Okay, thank you, counsel. Okay, Mr. Carlisle, whenever you're ready, sir.
Morning, Your Honor. Thank you very much. May it please the court. My name is Chris Carlisle, and I represent the appellee, Micah Graham. Your Honors, the starting point, I think, in this has to be what the standard of review is and what we're talking about here. Judge Webster mentioned a couple times about being a matter of law, and even in their reply brief, they suggest that this was improper as a matter of law. And I think that is a misstatement of what we're dealing with here. This deals with the admission of evidence. And if you look at both Dixon and Swanson, it talks about it being a discretionary call. So I think a starting point to suggest that as a matter of law, it's per se inadmissible to admit evidence of intoxication is not the correct statement of the law. And all these cases have to be decided on a case-by-case basis based on the circumstances that are present. I think Judge Cohen made an excellent point, and one that's occurred to me a lot getting ready for this oral argument. Even assuming that you admit liability and you admit liability for punitive damages, the same jury is going to hear the evidence of those things. And you have to voir dire the jury concerning their positions on intoxication, etc. So therefore, in virtually every case, even in the case we're talking about here, where they have admitted liability and liability for punitive damages, there's going to be something that comes in that the jury at least is going to have an inkling about what is at issue in the case. And that
there's a big difference between questions asked during voir dire and instruction by the court. Wouldn't you agree?
There is. But the point being, though, that it's impossible to keep out any sort of suggestion of intoxication in these types of cases where intoxication will be an issue in the punitive damage case. So therefore, all I'm suggesting, Your Honor, is that all of these cases have to be decided on a case-by-case basis based on the individual circumstances.
Well,
And
but I
that-
mean, in voir dire, I mean, couldn't you just, before you get into it, just say, all right, you ask questions, you or anybody been involved in a car accident when there's been any injuries? And then if nobody has, then you move on. If somebody has, then you ask more particularly about that. And I mean, I understand that, we've talked about this before, there were argument, the concern about voir dire, but why stipulate the punitive damages, that you're liable for punitive damages if all that evidence is going to come into the compensatory damage, trial anyways? That seems inconsistent with part of our theory of trying cases, is to narrow the issues and resolve matters before you present it to the jury. I mean, here it's this intoxication, as Judge Cohen was kind of throwing the bait out. Mr. Byrd talked about it quite regularly in a case where it really wasn't the issue. I mean, whether you were hit by a drunk driver or a sober driver, when you concede entitlement to damages, and your client wasn't making any claims saying, well, my mental anguish was worsened because I knew I got hit by a drunk driver, the whole point is defeated, I think, by how Mr. Byrd presented evidence and argument here. That's at least how I see it.
Well, Your Honor, there's a couple points on that. There is a distinction, obviously, between questioning the jury about feelings about drunk driving, et cetera, versus having it be admitted into evidence and a larger extent in a trial. However, I think I'm assuming that's what the discussion was prior to this. The point being that in any of these situations, even where that's admitted, it's going to come in to a certain extent and play a part in the jury's mind. Now, the question then becomes relevance and going forward in these types of cases. And again, we cited the White versus Westman case, which talks about the jury having the ability to understand the circumstances of the accident. They admitted liability, but they didn't talk about what actually caused it and talked about or admit what the facts of this were. And when you have a car going 35 or 40 miles an hour, when he sees it coming, when he knows that it's going to happen, the evidence of intoxication helps explain the circumstances of that. And secondly,
how does that explain the circumstances any more than if the driver was texting, a distracted driver? I mean, he hit him at 40 miles an hour. You can't just stipulate to liability and not get into the mechanics of the accident, but the reason why he hit him at 40 miles an hour, why does that matter?
Well, Your Honor, I think, again, there's in White versus Westman, in most instances, the quote from the court is, evidence describing the details of accidents are logically relevant and admissible, where liability has been admitted to place the extent of the injury suffered by the plaintiff in context.
Well, how fast he got hit, what the circumstances were, it has nothing to do with, as Judge Harris has just pointed out, it has nothing to do with why the second driver was negligent. That's not why, it's whether he was and how fast was he going, what are the physics of the crash and what resultant injuries were suffered.
Well, Your Honor, again, I respectfully, I think that there is some relevance to when he sees the car coming. He has a claim for pain and suffering and for emotional damages. And even though the evidence was not as extensively brought forth as maybe it could have been in a different circumstance, it was an element of the case. They didn't object to the jury being instructed to the issue of mental anguish being part of this claim. And so there is a discretionary call about the relevance of this.
You all withdrew any claim for that.
Well, we didn't withdraw it. There was a discussion about how that the specific issue concerning the intoxication was not going to be a feature of the pain and suffering or the emotional damages, but they were still instructed, and it was part of the thing. And obviously, pain and suffering was a part of the verdict that was rendered.
Where is can you explain to me the failure of the logic in the Swanson and Dixon cases? Why do you think that those are if we think that they're persuasive, why do you think that that the logic of those opinions is incorrect?
Your Honor, I think, again, as I mentioned at the outset, the starting point in both Swanson and Dixon talk about it being a discretionary call for the trial court. There is not a, quote, per se rule that they adopted in those cases saying that if you admit liability and you admit punitive damages, that it is absolutely excluded. So
it seems, though, that you guys are talking out of both sides of your mouth on this, because Mr. Byrd continually went out of his way, I mean, really out of his way, to say, well, you know, the fact that the individual was drunk has nothing to do with the amount of compensatory damages. And he uses the example of the vase in the trunk of the car. So on the one hand, you're saying, well, it's relevant. And then on the other hand, Mr. Byrd repeatedly through the trial, I mean, a lot, said, well, this has got nothing to do with it. Well, which is it?
Well, Your Honor, again, once the court determined that the evidence was coming in, I think it was entirely appropriate for counsel to instruct the jury or inform them over and over.
Why did the judge decide it was coming in?
Your Honor, there were the reasons that were set forth in the discussions prior to trial were the relevance to the emotional distress claim, but also the concept that the jury instruction and the case law required a finding by the jury on the punitive damages, even though that it was admitted that it was appropriate, or that they were part of the case.
So you're saying if you stipulate to the entitlement to punitive damages, the jury still has to find that?
That was the discussion that took place below, Your Honor.
And how does that make any sense? I mean, that's like saying
I'm not suggesting that again. And the trial and Judge Webster in their brief pointed out the trial judge did kind of raise a question about that, suggesting that. However, the question becomes:
who was it that suggested that?
I'm sorry, the judge at one point when they were going over the.
Who was it that suggested that that's what the judge needed to do?
It was the plaintiff from the beginning of the trial, Your Honor.
That's right.
And it goes to the jury instruction, which requires that finding. 503.1 has in the notes that instruction is to be given in every case involving bifurcation. It doesn't make a distinction about whether there are stipulations concerning punitive damages or not.
So when a defendant stipulates to negligence, you still have to forget about punitive. You still have to have the jury make that finding instead of the judge actually checking yes on question number 1 on the jury verdict, which all of us trial judges did when the defendant agreed to that.
Your Honor, I'm not suggesting that it could have been that could have been eliminated from this case, because again, the jury was instructed that punitive damages were admitted. But the question becomes, even assuming that they shouldn't have been forced or asked to make that determination, what is the potential harm, or how on earth did that impact this case in any way? If they had perhaps rejected the judge's instruction and found that punitive damages weren't warranted, that might have been an appellate issue. But the question becomes, okay, if there was some confusion concerning past cases requiring a finding by the jury, and also the jury instruction, which requires them to find that, maybe it's far from clear. Maybe when they drafted the jury instruction after the case from the Supreme Court, they should have put something in there concerning, all right, if they admit punitive damages, et cetera, maybe we don't need it. The instructions are again.
Isn't that self-evident though? I mean, you're saying that because the note on use or the comments don't say, and oh, by the way, if parties actually agree to it, you don't have to ask the jury to make findings.
I
You're
don't.
saying because that's not in the instruction, the comments or the note on use, what do they call it now? That you're now bound to ask them to make a finding that's stipulated to by all parties. I mean, it seems like Mr. Byrd got his cake and eat it too, saying, we agreed before trial to stipulate, but I still want the jury to make a finding because I want to be able to put all kinds of intoxication evidence in here.
Your Honor, again, I think that it's far from, again, I don't know if there's, I think that it's far less than clear concerning jury instruction and concerning the law. And so as a matter of trying to create a record, if it is somehow required based on the case law and based on the jury instruction, trying to clean that up and have that finding made is of no harm whatsoever to the defense, especially when they are instructed otherwise. So getting back to
harm to the defense, I mean, how many times during the course of this trial did Mr. Byrd put in or talk about evidence of intoxication? Can you give me a number on it?
I don't have the exact number, Your Honor, but I know it was a 10-day trial. And I know the main focus of the trial was medical evidence and medical damages. And I also know that he put in a disclaimer consistent with the jury instruction that the jury was to receive concerning this.
All the time. And that's part of that's part of my difficulty with this case.
Well,
it seems obvious, Mr. Carlisle, that this was a very specific strategy to wave this flag in front of the jury time after time after time, all while telling them, oh, but don't worry about this, forget about this, don't consider this. And it appears to me, at least, that was a very specific strategy by Mr. Byrd.
Well, Your Honor, I can't speak to a strategy that was employed here, but again, I would only say that when the jury was going to be instructed essentially along exactly the lines that he was informing the jury, I don't know if it's a strategy that can be somehow thought to be nefarious or negative.
So
the
he
jury was instructed not to consider.
He walks the judge down a path by saying, well, regardless of the fact that they're stipulating to this, the jury still has to make a finding so that he can then go ahead and put all this in front of the jury. And you think that that's no harm, no foul?
I was more talking about the comments that were made that were in conformity with the jury instruction concerning that they shouldn't consider that and whether or not that was improper or not. I think, again, Your Honor.
Mr. Carlisle, you think it's okay for Mr. Byrd then to ring the bell with his right hand, left hand hold up evidence and say, don't listen to that bell?
Well, Your Honor, I'm not suggesting that's what occurred here. I think that once the evidence was allowed to be in, it was entirely appropriate for him to suggest the proper context for the jury to consider it in conformity with the jury instruction.
Because he convinced the judge to let that in. Yeah, I mean, I agree that once the judge says it comes in, then obviously you should put in evidence consistent with the judge's ruling and then roll the dice at the appellate court. But when you convince the judge to do that, I mean, it's not like Mr. Byrd says, Judge, we can't have any of this stuff in. And the judge says, well, no, I've read the comments to the instruction and you got to have that in. And Byrd says, well, if that's what you're going to do, Judge, that's what I guess I got to do. That isn't it at all. I mean, he's the one who set the table, as Judge Cohen basically is saying. And then he ran with it. And then at the end, now he's handed the baton off to you and say, well, just tell him that really didn't matter all that much. That, he kind of put the disclaimer up at the end and said, I know you've heard of mountains of evidence, but you really shouldn't apply it here.
Good luck. Your Honor, I would respectfully disagree that it was mountains of evidence. And one of the things that is,
more than molehills, but less than mountains.
And certainly less than Dixon and Swanson. If you look at the facts of those cases and how it became more of a feature of the trial, and they had expert testimony concerning drug use, and they had numerous witnesses talking about that. So I think, again, I know where you're coming from on all these points, but again, we need to look at also the context of the fear and the danger that is present and Judge Cobb warned about, which is inflaming the jury to award excessive compensatory damages. And the big picture of this case is that's not what happened here. The trial court was aware of all the stuff that went on here, aware of all the evidence that came in. He denied the motions for mistrial, and then he denied a motion for new trial on this. And why was the motion for new trial denied? Well, in part, perhaps because of what the jury rendered. What we have here is not an excessive verdict. There's no evidence in this case that the jury exceeded any evidence that was presented to them concerning the compensatory damages. The past medicals were exactly in line with what was claimed.
Well, but if it's error, you under special have to then prove it's harmless error, don't you?
And I'm attempting to prove that it's harmless error in the sense that how is it error when the jury rendered a verdict? They don't challenge the numbers. They don't say that was inappropriate.
That's not persuasive. I have read many transcripts. You've been practicing before this court before I got on it, and you've been here for the almost 13 years that I've been on the court, and I've read many transcripts in your cases where there were all kinds of issues below, and you made an election not to to challenge all of them, but to pick your strongest appellate arguments. And that's what, that's what Mr. Webster's done. And I don't think that we draw any inference from that, in terms of his decision that these are the issues that I'm going to, brief and argue. Before we let you sit down, I'd like to, well, you are sitting down, but I'd like to talk a little bit about the expert witnesses in the case, because I'm troubled a little bit that with the concept that you can hire your good friends as experts. You make that decision that you're going to hire your good friends as experts, but yet the defense doesn't get to cross-examine them, on that. And particularly in light of how late the designations were on the one, I mean, I don't know how possibly that ruling can stand when he doesn't let the defense then pursue it because the designations came in the day before the trial was supposed to start.
Well, Your Honor, if I can back up to your previous point and I'll answer that. I was obviously not suggesting anything about my good friend, Mr. Webster, and the issues he raised on appeal. I was merely suggesting that the harm that is potentially coming from the inflaming of the jury is not present or reflected in this jury verdict. And I understand your point on that. Concerning the experts, again, we're talking about discretionary calls here, and you're talking about two different circumstances. And I think it's critical to point out and very important to point out, we're not talking about a party who has a relationship with an expert. We're talking about an attorney, and we're not talking about a hired expert per se. We're talking about a treating physician. And those are,
you know, you don't think that we understand how plaintiffs get sent to treating physicians? You know, we've all practiced law. You know, we know how this works.
well, Your Honor, again, this is a discretionary call, and I think that the trial judge, especially on the first witness, was we objected to allowing any evidence of the friendship there as being irrelevant. The trial said, no, I'm going to allow it. I'm going to allow evidence that they're friends and the duration of the friendship. Getting into the specifics of that and going further than that, when you're talking about a treating physician and an attorney, you can't say that was an abuse of discretion sufficient to undo a 10-day jury trial concerning the extensive.
When a lawyer elects to call experts who are his friends, why isn't that appropriate?
Your Honor, it was appropriate, and I'm not suggesting the trial court abused its discretion by allowing inquiry about it, but where is the extent of that? And being former trial judges yourselves, there can't be extensive and rabbit holes going down during trial that on collateral issues. The fact of the friendship and the duration of the friendship was presented to the jury. Can it be said that no other judge in the state would have not allowed more than that? No.
Well,
it was
I suspect you're looking at three who would have allowed it, but that being said, I get the abuse of discretion. You know, maybe the judge down in Cape Coral wouldn't do it, but it's one thing to say we're friends, we're good friends. Was one of them was the groomsman or the best man, and that somehow is not pertinent?
He was a groomsman.
If you want me to say the magic words, I think that's an utter abuse of discretion to not allow that.
Well, Your Honor,
that makes zero sense to me, frankly.
Well, Your Honor, again, all I can say is that in the context of this, the trial court had the discretion to make that call. He let them know they were friends. We're talking about an attorney and a treating physician versus an expert, perhaps, that had a long-standing relationship. There's no evidence about Mr. Berg's firm having a relationship to this doctor, et cetera, the things that you're worried about.
You're going to hang on to Worley till grim death until they reverse it up in Tallahassee, aren't you?
Yes. Your Honor, I see my time is up. If there are no other questions, I'll stand down.
Oh, no, we'll give you some extra time. We're having fun.
Oh, I know. Well, thank you, Your Honor.
All right.
Mr. Webster, 3 minutes and 8 seconds.
I'll try and talk very quickly, Your Honor. First of all, on the standard of review, we have three issues, as I explained. The first issue is that the trial judge ruled incorrectly as a matter of law that he had to submit the issue of entitlement to punitive damages to the jury, notwithstanding McKinney's admission that he was liable. The standard of review for that has to be de novo. He did it based on the plaintiff's lawyer convincing him that W.R. Grace and the standard in jury instructions required him to do that. I submit that for all the reasons we cite in our brief, those two justifications were just nonsense. The harmless error argument here, it seems to me, defies comprehension. What we had based on the first, and let me say the other two issues are evidentiary issues. The standard of review is abuse of discretion, but the scope of that discretion is subject to the rules of evidence. It's constrained by the rules of evidence. If in fact the evidence was not relevant, then it should not have come in as a matter of law, and it was an abuse of discretion to let it in. If you disagree with all of that, I respectfully suggest you're going to have to certify conflict with both Swanson and Dixon, both of which held that when liability for punitive damages was admitted, that ceased to be an issue in the case, and no evidence regarding intoxication should have come in. Harmless error.
Well, let's talk about the award of damages. Obviously, the past medicals and the future medicals. Was there evidence to support those amounts?
Sure, there was, but that's not the test, Your Honor. The test under special is whether the beneficiary of the error can demonstrate that there's no reasonable possibility that the errors could have contributed to the verdict. And let me point out on that issue, 4 times in their brief, they substitute the word probability for possibility when setting out the harmless error test. Sure, there was evidence, Your Honor, but there was also evidence to the contrary. We put on expert evidence that plaintiff had a pre-existing degenerative condition in his spine.
No, you did. That's shocking.
But that's precisely why this can't be harmless error, because there was evidence on both sides, and the burden is on them to demonstrate that there's no reasonable possibility that it could have affected the verdict.
But there would be no way to know the pain and suffering award, how it was impacted by this testimony, would there?
One way or the other, no, absolutely not. I see my time is up. For all of the reasons I've expressed, we submit that we're entitled to reversal and a remand for a new trial on compensatory damages. Thank you.
Okay, thank you, gentlemen. Very good argument. We enjoyed listening to both of you. We'll stand adjourned right now.
And the briefing on the case, by the way, it was excellent on both sides. So I commend both the briefing and the oral argument. You both did an excellent job.
Thank you very much.